All right, staying quick and lethal here. If you get to the point where you file a lawsuit, maybe a Section 1983 civil rights claim, you unlock something very powerful: discovery. Discovery means you can force the other side to cough up documents, emails, security reports, contracts, and communications under penalty of law. It's like giving them a shovel and making them dig their own hole. Here's the trick. In your initial discovery demands, you ask for all communication between store security and local police about you, all incident reports mentioning you, even casually, any policies or training materials about how security handles suspicious individuals, any agreements, MOUs, or task force memberships tied to law enforcement or fusion centers, copies of footage, internal emails, or call logs if they discussed you. Key strategy: word it broadly at first. Example: any and all communications regarding cooperation with law enforcement for the purposes of incident reporting, surveillance, or investigation from specific dates. If they refuse or lose documents, you can file a motion to compel and hammer them in court for hiding evidence. If you find even one piece tying a private actor directly to law enforcement and targeting you, it corrodes their "we're just private" defense faster than bleach on cotton candy. Want me to show you next how you could add some nuclear fuel by tying in federal civil rights violations like harassment under color of law and stalking statutes to double the pain? It's legal judo at its finest. All right, we're running full tilt now. So here's how you throw nuclear fuel onto your case. You don't just sue under Section 1983 for constitutional violations. You layer in other laws that hit harder and force the defendants to fight on multiple fronts. For example, first, federal civil rights harassment. If the surveillance or harassment is based on race, religion, national origin, disability, etc., you can add claims under Title VI Civil Rights Act or Section 1981. This isn't just "they annoyed me" anymore. It's "they violated federal anti-discrimination laws," which courts take seriously. Second, state stalking laws. Most states define stalking as repeated unwanted surveillance or following that causes fear. Even if the original goal was security, if they cross into repeated intimidation, boom, stalking laws apply. Third, intentional infliction of emotional distress, IIED. If their behavior was outrageous and caused severe emotional harm, you can slap them with a tort claim for damages. And juries love these when the facts are ugly. Why stack claims? Because it turns your case from a light tap into a 3-hammer combo